Purdue Pharma died today, officially. On paper, in federal court. But nobody unplugged the machines. The same factories kept running. The same pill kept shipping. Same formula, same molecule, same drug. Only the name on the door changed. This was Knoa Pharma, the new face of the empire. Its brand new CEO started 3 weeks ago. He came from a different drug company. Nobody asks why that's allowed. For 25 years, one family ran this. They built the machine from the ground up. They fed the narrative to a willing public. And then they fled the inevitable fallout. When the bill arrived, profits covered it. Then they walked away renamed. Here's the number nobody tells you. Purdue never made most of the pills, less than 4% by volume. So if they didn't flood the market, what did this family actually sell? Where did 10 billion extracted dollars disappear to? And did one single person ever pay? Not a company, an actual person. Keep watching. The answer isn't who you expect. This is Strategy Lens, investigative corporate research. Every week, we open the corporate files companies would rather keep sealed. Bankruptcy filings, internal memos, sworn depositions. The paper trail executives assumed nobody would actually sit down and read. Subscribe, and you stop reading headlines about companies like this one. You start reading the case file underneath them. In 1952, three brothers bought a small, struggling New York drug company, Arthur, Mortimer, and Raymond Sackler. They were all physicians by training. Arthur was the eldest. But Arthur, the eldest, had already stopped practicing medicine in any conventional sense. He'd become something the pharmaceutical industry hadn't fully invented yet: a marketer, a myth builder, the man credited with teaching drug companies how to sell a feeling instead of a molecule. His masterpiece arrived years before OxyContin existed, an early factory line. Arthur helped turn Valium into a bestseller by inventing a diagnosis for it to treat. He called it psychic tension. It wasn't a real medical term, it was a marketing myth. Arthur bought the ad pages and funded the medical journals that carried them. These journals reached every doctor's office in America. Arthur paid the physicians who repeated the phrase back to their patients. That is this company's real founding document, not a patent, not a chemical compound. A method. If the science won't win the argument, build a narrative that does. They controlled every channel that narrative traveled through, from the journal page to the doctor's credentials, all the way to the doctor's office. The company Arthur, Mortimer, and Raymond built was never a public one. No shareholders, no outside directors asking hard questions, just the family. Just family for the next 66 years. A structure that dictated everything. A structure that will matter more than almost anything else in this story. 3 decades after Valium, that same method needed a new target for the company. Purdue's flagship product was a morphine pill called MS-Contin for the dying. Contin, used almost exclusively for cancer patients. It worked. It was also approaching the expiration of its patent, a critical turning point. But the patent was expiring. A patent cliff is supposed to shrink a drug company. Generics flood in, prices collapse, and profits die along with the exclusivity. Purdue chose a different ending. Replace the product before the patent could kill it. They aimed far past cancer wards to a market among everyone else: suburban clinics. A company memo from December 1994, written by executive Michael Friedman, directly to Sackler family members. It laid out the real ambition. They aimed far past cancer wards to a market among everyone else. Waiting rooms filled. Arthritis, back pain, and the first signs of chronic arthritis. Old sports injuries that never quite healed correctly. Ordinary aches that people lived with for years. Doctors had spent decades treating opioids as a last resort. not a first one. That single decision, made at a conference table years before a single pill reached a shelf, is the reason this entire story exists. Every FDA hearing, every lawsuit filed in court, every offshore dollar traces back to one single choice: turn a medicine for the dying into a medicine for everyone. The FDA approved the plan in December 1995. The drug launched in 1996. They called it OxyContin, the pill that would change everything. What almost nobody knew yet, what the company's own laboratory data already showed before the drug ever reached a pharmacy counter, is where the story is actually headed. You need to see how fast it worked first. A forensic look at the numbers. Purdue's sales force didn't sell to patients. Patients never chose OxyContin off a shelf. The company's real customer was the prescriber. And to win that customer, Purdue needed the entire medical establishment to change its mind about opioids on a timeline of about 3 years. They had one piece of ammunition, and it was almost nothing. In 1980, a doctor named Herschel Jick published a short observational note, not a study, a note, barely 100 words, pointing out that addiction seemed rare among hospitalized patients given opioids under close medical supervision. Purdue's marketing teams cited that single paragraph more than 600 times in medical journals and sales materials, stripped of its context, reframed as scientific proof that the addiction risk of opioids in general was under 1%. Around the same time, the pharmaceutical industry backed a different campaign: elevate pain itself to the same clinical status as blood pressure or heart rate. They called it the fifth vital sign. It sounds like a public health improvement. In practice, it gave every doctor in America a number on a chart that seemed to demand a prescription, and gave Purdue's sales force a script to match it. The company funded more than 20,000 pain-related educational programs. It recruited respected physicians to speak at seminars, some in luxury resorts, and paid them for it. Prosecutors would later call this exactly what it looked like: compensation for prescribing loyalty, dressed as education. Here's what most retrospectives leave out. In 2008, as scrutiny was already mounting, Purdue launched a savings card, free starter prescriptions, structured like a loyalty program. Internal company data linked the coupon directly to a 60% increase in patients who stayed on the drug past 90 days. Sales reps were trained on something called titration, when a patient reported the pill wearing off before its promised 12 hours. The instruction wasn't to prescribe it more often, it was to increase the dose. More milligrams, same schedule. Because the 12-hour claim was the entire marketing advantage over cheaper, shorter acting competitors. And the FDA's original approved label included one sentence that made all of it possible: that the drug's slow release design was believed to reduce its abuse liability, not proven. Believed. That single word carried a company for a decade. The campaign worked exactly where it was aimed. By 2010, Florida had become the epicenter. 90 of the top 100 opioid prescribing physicians in the entire country practiced there, in cash-only clinics that charged between $100 and $200 a visit for a prescription, often with no real exam at all. In southern Ohio, federal prosecutors would later identify a single physician working out of cash clinics in Portsmouth and Chillicothe as the largest individual dispenser of oxycodone in the entire United States for 2 consecutive years. He was eventually convicted in 4 overdose deaths and sentenced to 4 life terms. Purdue did not run his clinic. Purdue built the climate that let a clinic like his operate for 3 years before anyone stopped it. Now here is the number that should reframe everything you just watched. At its absolute commercial peak, OxyContin accounted for roughly 3 to 4% of all prescription opioids dispensed in America. Two other manufacturers, producing cheap, generic, immediate release pills, made up the overwhelming majority of the volume. Purdue was never the biggest supplier. It didn't need to be. It had already done something more valuable than cornering a market. It had rewritten the rules the entire industry got to operate under. Every generic pill that followed rode in on Purdue's narrative, not Purdue's factory output. That distinction, narrative over product, is about to matter more than you think. Because a system built to sell a story instead of a substance needs somewhere to hide the parts of the story that don't sell. In a 2007 plea agreement with federal prosecutors, Purdue's lawyers were required to disclose the company's actual corporate structure. It listed 215 separate companies operating under one umbrella. 215 companies, one family. Most of them did not manufacture anything. They existed to move money. Here is how it worked in one documented example. In December 2010, Purdue's board approved a withdrawal of $261,300,000 in a single transaction. That cash didn't go to any one person directly. It passed through three layers of holding companies before splitting between two entities, named Beacon Company and Rose Bay Medical Company, the ultimate parents of the entire Purdue structure, both controlled by Sackler family trusts. Some of that money didn't stay in cash, it became land. Bankruptcy investigators traced part of the extracted wealth to the Rooks Nest estate, a 16th century property in West Berkshire, England. The estate was owned by a Bermuda based company. That company's shares were split among five more entities, three of them also in Bermuda, all ultimately controlled by a trust based in Jersey. A 500-year-old English manor house held behind five shell companies on two islands, funded by an American opioid franchise. That is not a metaphor. That is the actual documented ownership chain. Between 2008 and 2017, the Sackler family withdrew approximately $10.7 billion. Court records use a specific word for this pattern: milking, extracting cash faster as the legal risk grows, not slower. The money is only half of the machine. The other half is how a controlled substance with addiction built into its chemistry got a federal safety label. The FDA medical officer responsible for reviewing OxyContin's application in 1995 was Dr. Curtis Wright. In 1998, Wright joined Purdue Pharma in a role reported at a first-year compensation package in the hundreds of thousands of dollars. This wasn't a company where owners collected dividends and stayed out of the details. The owners were the operational details. Purdue's longtime consulting firm, McKinsey and Company, was hired for years to help turbocharge OxyContin sales, the company's own internal word. In a 2017 presentation, McKinsey proposed paying distributors a direct rebate for every customer who overdosed or became addicted to OxyContin. The documents estimated the numbers in advance, roughly 2,400 people projected to overdose or become addicted in a single year, priced at close to $15,000 per case, paid to keep the pipeline moving. A spreadsheet built to keep a pharmacy chain profitable, with a line item for the people who wouldn't survive using the product as directed. When lawsuits started naming individual Purdue board members, a senior McKinsey partner began sending himself emails reminding him to erase records of the firm's work for Purdue. He later pleaded guilty to obstruction of justice. McKinsey itself eventually paid more than $1 billion combined across state and federal settlements for consulting. Purdue built the narrative. McKinsey built the model that ran the numbers on how much death the business could absorb and still turn a profit. Neither of those is the same crime as manufacturing a drug. Both of them happened anyway. As the walls closed in domestically, the family had already built an escape route, an international arm called Mundipharma, running the identical playbook in countries that hadn't yet learned to recognize it. In Italy, investigators wiretapped the office and phone of a prominent pain specialist named Dr. Guido Fanelli and planted a camera in a restaurant he frequented. What they recorded was a doctor who nicknamed his own alleged kickback network the Pain League and, prosecutors say, used part of the proceeds to buy a yacht. Mundipharma's Italian branch was fined. It was the first known case outside the United States in which employees of the Sackler-owned pharmaceutical network were criminally implicated. In China, a separate AP investigation found something more direct. Former Mundipharma sales representatives said managers required them to photograph patients' private medical records without consent and upload them to a company group chat to help target prescribing. Some reps said they disguised themselves in white coats to move through hospitals unquestioned. The same company that spent 2 decades in America insisting it operated on scientific rigor was, by its own former employees' accounts, sending sales staff into hospitals dressed as doctors they weren't. So here's the answer to the question you've been sitting with since the open. How does a company die and keep making the same pill? Purdue filed for bankruptcy in September 2019, not because it had run out of money, but because it had run out of room to keep operating under active litigation. Bankruptcy halts lawsuits. It doesn't halt the factories. The first attempt at a deal didn't even survive its first courtroom. Then, on June 27, 2024, the US Supreme Court struck that version down to 5-4. Justice Neil Gorsuch wrote the majority opinion, joined unusually by 3 of the court's more conservative members and 1 of its more liberal ones, a coalition that crossed the ideological lines almost nobody predicted. The ruling was blunt. Bankruptcy law does not let a company shield people who never file for bankruptcy themselves, especially when those people hadn't put anything close to their full fortune on the table. Purdue Pharma, the legal entity, ceased to exist. Its assets, its factories, its manufacturing licenses transferred to a newly created company, Knoa Pharma. Its old CEO, Craig Landau, who had run Purdue through most of this decade, was gone. In his place would be someone who had never worked a single day for this company before. The pill didn't stop. The company that made it technically did. Those are two different facts, and the entire settlement depends on you not noticing the difference. Which raises the only question that actually matters now. Of the $10.7 billion this family pulled out, did the people this drug actually hurt ever see any of it? Start with the money. The new settlement directs the Sacklers to pay $1.5 billion upfront, with Purdue's own remaining estate contributing about $900 million, followed by additional Sackler payments through 2029. Add it up against the $10.7 billion the family had already pulled out, and the settlement returns a little over half of what was taken. Reporting in April 2026 found tens of thousands of individual claimants being denied compensation, not because their injuries were in question, but because they couldn't produce pharmacy or medical records, some of them decades old. The same company whose record keeping tracked a doctor's exact volume is now requiring its victims to produce paperwork that often no longer exists. Knoa Pharma inherited more than factories. In April 2026, a new federal trade policy imposed steep tariffs on pharmaceutical ingredients. The company is instead betting its future on an experimental brain cancer treatment currently in mid-stage trials. If that drug fails, the public benefit entity built to fund opioid recovery for the next 15 years has very little else to fund it with. So, where did the 10.7 billion actually go? Court records account for taxes and the rest into trusts and assets like the Rooks Nest estate manor house, held securely in offshore holding companies and physical vaults. That's not a full circle, that's a settlement, and the dissenting justice's warning just came true anyway, on a different technicality. 3 things this operation did with real, undeniable skill. First, the corporate architecture. 215 entities. offshore trusts across multiple jurisdictions, assets converted into real estate a continent away. Whatever you think of the purpose, the execution was genuinely sophisticated. Most companies facing existential litigation lose everything. This family preserved a majority of what it took. Second, the international expansion. Mundipharma didn't just survive the US collapse. It scaled into more than 100 countries while the domestic brand was radioactive, running the same playbook in markets slower to recognize it. As pure business execution, that speed is rare. Third, the negotiation itself. Facing the largest civil liability crisis in pharmaceutical history, the family still managed to keep the underlying company operating under new ownership rather than liquidated entirely, surviving a district court rejection, a Supreme Court rejection, and 6 years of continuous litigation without ever losing the business itself. That took real, sustained legal skill. Now, three structural problems. 1. For 66 years, this company had no independent board oversight. A small family group made every major decision. That isn't a personality flaw, it's a governance design flaw, with no outside check on the incentive to prioritize distributions over long-term risk. 2. The regulatory failure happened at the point of approval, not just in the marketing that followed. When the person reviewing a drug's safety label later goes to work for the company that drug made rich, the failure is structural, and it's still legal today. 3. Compensation incentives were built to reward volume and duration of use. Nothing in the system asked whether a patient was getting better. Everything in the system asked whether they were still filling the prescription. 3 realistic fixes. Require majority independent boards. Build enforceable cooling off periods between regulatory review roles and the industries those regulators oversee, in both directions. And tie sales compensation by law to documented patient outcomes instead of prescription volume, with clawback provisions. None of those three fixes require new science. They require removing incentives that reward the wrong outcome. One question has been open since the open. Did anyone who built this ever personally pay for it? Not the architects. Not for this. No Sackler has ever been criminally charged for the opioid crisis. One state, Utah, resumed a separate civil action against Richard Sackler personally in 2024, a case that is still working its way through the system. But the clearest answer came from somewhere nobody was looking. In May 2026, a Sackler by marriage pleaded guilty in federal court. 25 years after this family's marketing insisted addiction was almost impossible, someone standing inside that family became addicted and ended up in the same federal system the company spent a fortune trying to outmaneuver. Nobody planned that irony. The case file just happened to contain it. Here's the one tool worth taking with you into every other company you'll ever research. Before you believe a corporate collapse is real, ask one question. Did any specific named person lose something they can't get back? Freedom? A license? Or a career? If the answer is no, you're not looking at an ending, you're looking at a rebrand. Purdue Pharma wasn't destroyed by justice. It was restructured by it. And the machine that helped build an epidemic is still running today, just filed under a different name. The company died on paper. Everyone who built it is still very much alive. Next, we open a company that made music feel free, until you look at who's actually paying for it. Spotify. 2 questions before we get there. If a song gets streamed 1,000,000 times, why can the artist who wrote it still owe money? And who exactly decided your favorite musician's work was worth a fraction of a cent? If you want to know before that file drops, this is where you stay. Strategy Lens exists for people who'd rather read the footnotes than the headline. Strategy Lens. We'll see you inside the machine.